Good morning, ladies and gentlemen. Siyadat wa Sadat, Assalamu alaikum wa sabah khair. Welcome to today's webinar on Bahrain's new reorganization and bankruptcy law. My name is Tom Gilbert, and I'll be moderating today's webinar. As the head of business development at Keypoint, Bahrain's leading professional services firm, we're excited to see Bahrain accelerating the development of a wide variety of regulatory arrangements. Just one reason that I was so pleased to be approached by the Bahrain Chamber's Finance, Insurance and Taxation Committee when they said they wanted to host a webinar on the new law. And it's obviously not just me that was excited at the prospect. I'm delighted to announce that we've had almost 300 people register for today's webinar. I see that we're over 100 participants already, so thank you very much to all of you for joining us. Your panel today offers an elusive mixture of genuine subject matter knowledge and the ability to share that knowledge in a way that is accessible to everyone. We have representation today from the body that developed the new law, a practitioner who's already dealing with the new law, a trustee, more on that in a minute, and an external expert who's been at the sharp end of reorganizations, as well as being part of a professional body that helps to develop trusted regulatory frameworks. Thank you very much to all four of our panelists for joining us. Let me start by introducing you to Dr. Jamil Al-Alawi. Dr. Jamil has been the Senior Legal Advisor at Bahrain's Economic Development Board since 2007 and was a key member of the team that wrote and developed Bahrain's new law. While his original focus was on civil engineering and transportation, he graduated from the University of London in 1996 with an LLB and is also a chartered arbitrator. Dr. Jamil will be giving us an overview of the new law, starting with a brief comparison with the old 1987 law and looking at the types and costs of proceedings, insolvency proceedings, transparency, and conservatory measures. Good morning.
Good morning.
Hi, Dr. Jamil. The second member of our panel is Ms. Fatima Hassan Al-Ali, who's a partner with Hassan Radhi Associates, one of Bahrain's most prominent law firms. Ms. Fatima specializes in corporate law, including company formation, registration, restructuring, mergers and acquisitions, and liquidation. She has broad legal experience, including arbitration, litigation, banking and finance, employment law, and intellectual property. A member of the International Bar Association, the IBA, and a certified arbitrator, Fatima graduated from Canada's Carleton University in 2009 as a Bachelor of Law, majoring in business law with a minor in economics. Ms. Fatima is going to focus on some of the key attributes of the new law. Good morning, Ms. Fatima.
Good morning, Tom.
Good morning. The third member of our panel, Shashank Chandak, is registered under the new law as a trustee, and that's what he's going to focus on during this webinar. As a manager in KPMG Fakhra's tax and corporate services function, he advises a diverse portfolio of clients with operations across the GCC on VAT, customs and excise, global trade, compliance, and litigation. A graduate from the University of Delhi, Shashank is a member of the Institute of Chartered Accountants of India, ICAI, and is an Australian qualified CPA. Welcome, Shashank.
Thanks, Tom. Good morning, everyone.
The fourth member of our panel today is joining us from Melbourne, Australia, an external expert who will share his perspective on international leading practice. Matt Gallant is a fellow of the Australian Restructuring, Insolvency and Turnaround Association, ARITA, and has significant insolvency and reconstruction experience, including here in Bahrain with a leading professional services firm. As a member of the state restructuring committees for both Victoria and Tasmania, Matt has also been instrumental in developing and delivering a range of training materials, an important part of the regulatory environment that Bahrain is looking to develop. Matt's extensive corporate administration and restructuring experience make him the perfect guide to 3 short case studies on how companies in Australia have benefited or not from reorganization, and offer some important pointers on how SMEs here in Bahrain might utilize the new law to get through restructuring. Some housekeeping points before we start. We've got a lot of people on the webinar. We're above almost at 120 now. We're very keen to make today's session as interactive as possible, and we welcome your questions. We will answer as many of your questions as we can. We're going to use the chat function to ask questions. There is lots and lots of time set aside for a Q&A session, And after today's session, we will circulate a summary of all the questions and the answers, as well as the slides that we use for today's webinar. If there are questions that we can't answer because of time or for other reasons, we will, wherever possible, use FIT, the BCCI committee, to get those answers to you as soon as we can. That brings me very neatly to my last point. Today's webinar is being hosted by the Bahrain Chamber's Finance, Insurance and Taxation, the FIT committee, which is headed by Ms. Sausan Abul Hassan Mohammed. We're honored to have Fatou Zayani with us today. A Bahraini national, Fatou has spent almost 40 years in executive management and business development in the regional and international insurance and reinsurance industry. Fatou spent 22 years with ARIG, where she managed MENA's largest international aerospace reinsurance portfolio, and has received numerous accolades for her contribution to the insurance and reinsurance industries. As a board member, she advises a number of international and regional insurance and reinsurance companies, higher educational establishments, and government authorities. She's also the International Insurance Society's ambassador for Bahrain. Welcome, Ms. Fatou.
Thank you, Tom. Thank you. Appreciate it.
So,
reorganization over bankruptcy, and to maximize the value of the bankruptcy or restructuring estate. In line with this purpose, a business continuity arrangement is allowed whereby the debtor may obtain unsecured financing and the business of the company can continue to a certain extent, but is overseen by a bankruptcy or restructuring trustee. My friend Shashank will talk in a lot more detail on the role of the trustee, but as a key attribute of the law, the role of the trustee is crucial, and that role is overseen by the court. In general terms, the trustee must do all things necessary to maximize the value of the estate and protect the rights of all creditors. And to do that, the trustee has a wide range of powers, including the right to access all information from any entity or authority that is required for the fulfillment of his role, and to employ any experts he deems required for that purpose. The trustee may be one or a panel of up to three. Now, I realize because of this technical issue, we're jumping on to the second section of the law. Dr. Jamil will talk about how to start bankruptcy proceedings, as well as provide a very good comparison between the old law and the new law. So we were talking about trustee requirements and saying that the trustee may be one or a panel of up to three. And they're appointed by the court upon approval of commencing reorganization proceedings based on the nomination by the creditor committee. And in the lack of a committee, which we'll talk a bit more about later, nomination may be submitted by creditors owning at least 50% of the total unsecured debts. In the lack of a nomination, the court appoints a suitable bankruptcy or reorganization trustee from the registered list of trustees. I'm seeing a chat saying that they cannot hear me. Can anyone hear me? Yeah, thank you. Thank you.
the line, it's very good. We can hear you very clearly, Fatima.
Thank you. So more on the trustee. The trustee must be registered in the schedule of experts and may not be an insider of the company or any of its subsidiaries, or a creditor or partner, employee, auditor, or agent of a creditor in the 2 years prior to commencing bankruptcy proceedings. And the role of the trustee is overseen by the court, which roles and powers include ordering the commencement of proceedings, approving the applications made by the trustee for the disposal or sale of any of the estate, ensuring the validity and value of the creditor claims, and making interim decisions and ordering any person with information that is related to the proceedings to submit that information to the court. And what the court and the bankruptcy trustee have to work with is the estate. And that is the assets of the debtor, including all movable property, whether acquired before or after the opening of the bankruptcy proceedings, as well as all payables and return on assets and proceeds from continuing business. There are assets that are exempt from being included in the estate to ensure a reasonable continuation of the debtor's everyday life. And those include social assistance by the state to the debtor, funds that are non-attachable by law, and these include things like the place of residence and the tools essentially required for the debtor's profession and continuity of business. Also, mandatory pension rights are exempt, spousal and dependent support, and on top of that, the court may also decide a reasonable allowance to be paid from the bankruptcy estate or the reorganization estate to the debtor if deemed fit. And to protect the estate, as soon as the proceedings are open, the court will order what's called a moratorium, which is one of the very key attributes of this law. And what that means is the suspension of all lawsuits, judicial proceedings, and execution proceedings against the bankruptcy estate or the debtor, including claims by secured creditors. And the purpose of that is to avoid any action by a creditor or group of creditors that excludes the others. Now, the moratorium may be initiated by the court before commencing proceedings as well as an interim measure. It starts with an initial term of 120 days, extendable by the court, and may continue until the conclusion of the proceedings. At any point in time, if the court deems it unnecessary or not effective for the purpose of value maximization, it may order the lifting of the moratorium. And the exemptions from the moratorium are mainly the enforcement of rights under financial derivative contracts and enforcement of letters of guarantee or letters of credit. The moratorium allows the full estate to be at the disposal of the trustee for value maximization purposes. And this allows the trustee to come up with a restructuring plan. Now, the debtor may submit his own proposal of a restructuring plan and obtain creditor approval on it before commencing proceedings. Other than that, the court would appoint a creditor committee, and this committee consists of up to 5 unsecured creditors with total claims amounting to at least 25% of total claims. The trustee must liaise with the creditor committee. The creditor committee has a very key role, and the trustee must liaise with it to propose a restructuring plan to be submitted to the court, and the plan would be subject to creditor vote. And the majority required for creditor vote is that all categories of creditors must approve, and within each category, a 2/3 majority of claims must approve. The plan is then submitted to the court to ratify, and upon court ratification, the plan is binding on all creditors. And in the case where the trustee doesn't make progress on the plan, then creditors with claims amounting to at least 1/3 of the total claims may submit a restructuring plan subject to court approval. And this plan would be subject to creditors' vote as well. Now, we've talked about how the law allows for the debtor's business to continue, and for that, the sale of assets within normal course of business can be allowed. But other than in the normal course of business, the sale of assets is prohibited unless the trustee deems it required for the purpose of value maximization, and that is subject to court approval. The method of sale is required to also serve the purpose of value maximization, and for that, expert assistance may be sought. In case of a secured asset, the disposal may be done free of security only with creditor's consent, and only if the proceeds are not less than the debt or market value, and the disposal is within the restructuring plan. The law allows any creditor objecting to a sale to submit his objection to the court, and the court will decide on it based on its own discretion. On the sale of assets also, the law recognizes that there may be cases of an emergency or urgent sale, which urgent nature does not allow the trustee sufficient time to obtain court approval. In that case, the trustee may conduct the urgent sale, but will be required to submit a post-transaction justification report to the court. And if the sale is for substantial assets of the estate, then the approval of the creditor committee, or in the lack of a committee, the approval of at least 50% of the unsecured debts is required. And that must be reported to the court with sufficient detail by the trustee. What happens to existing contracts? Now, the trustee must initially continue to meet the contractual obligations in the course of proceedings, but then has to make a decision in respect of existing contracts. And that's whether to continue to assign the contract to another party or to rescind the contract. And this has to be in line with the essential purpose of value maximization. Of course, court approval and notification to the other party to the contract are required in all cases. Now, the commencement of proceedings subjects the conduct of the debtor before and during the proceedings to judicial review. So upon commencing restructuring proceedings and in line always, restructuring or bankruptcy proceedings, and in line always with the purpose of value maximization, the bankruptcy trustee can submit a request to the court to set aside or nullify any disposal by the debtor or any obligation retroactively borne by the debtor in the following conditions. So if it's a fraudulent transaction, it can be set aside. If it's a harmful transaction, if it's a transaction under which the debtor assumes obligations that do not achieve interest to him, or for which no fair consideration is received, and if that transaction factors to or leads to the bankruptcy or the reorganization. And finally, disposals giving preferential treatment to creditors, while the debtor is unable or will become or is likely to become unable to pay its debts. The trustee shall submit to the court a request for the nullification or the setting aside of such transactions within 6 months of deciding on opening the bankruptcy proceedings. And in the case of set aside, then the trustee may recover the right or asset disposed of or the value of that asset from the other party to the transaction. And all these procedures take us to the purpose of repayment of debt, which will occur in an order of priority. So the first thing that must be paid is any unsecured debt obtained after opening the bankruptcy proceedings. Then comes administrative claims, which are the expenses relating to the restructuring procedure itself. Third in line is employee salaries, and that's subject to a maximum value of 3,000 BD per employee. And then payments to customers and government taxes and fees, and each of these are also subject to a maximum value per customer per government authority. Next in line is all other claims which arose before commencing the bankruptcy proceedings. Then come the claims not submitted in time to be included in the restructuring plan. Then the claims by foreign government authorities in relation to taxes and other fees. And then compensation to unsecured creditors for default of payment. And finally, the claims by the shareholders of the debtor. Information about the cases for bankruptcy or reorganization are available on the website of the Ministry of Justice, Islamic Affairs and Wealth, and they remain there for a period of 12 months after the conclusion of the case. And what you can find there is a full file including all the information, decisions, details, and documents of the bankruptcy or reorganization case. And they continue while the case is ongoing and for a period of 12 months thereafter. The court may decide to exempt certain information from the publication requirement if deemed required for the protection of business secrets or reputation. So far on the website, there are 10 ongoing cases available for viewing. Thank you very much. I think we now either go back to Dr. Jamil if the problem is fixed, or move on to the more interesting practical side of things with Shashank.
Thanks very much indeed, Ms. Fatima. I think that Dr. Jamil, I think we've managed to overcome those technical issues. So in slightly backwards order, can we ask Dr. Jamil to go over his slides for us, please?
Okay, thanks, Tom. I was saying that the drafters of the new law were tasked with developing a law that is in line with best and most modern international practice in the field of insolvency. And in the 2020 report produced by the World Bank on the ease of doing business, Bahrain was given the highest score among countries in the MENA region for its insolvency law. I believe it would be fair to say that this score is a testament to the success of the drafters of the law and the legislative authority in Bahrain in developing a law that meets the highest standards. There is a word of difference between the old law and the current law. I would very quickly walk you through the most notable differences between the old law and the new law, and the most important enhancements that the new law contains. One of the most important differences between the old law and the new law is the fact that the new law contains provisions which are very similar to those within Chapter 11 of the United States Code, which I'm sure is familiar to most of you. These provisions allow a company facing financial difficulties to undergo reorganization, where there is a reasonable chance for it to stand up on its feet again. There is also provisions within the law as far as reorganization is concerned, where the debtor has a few creditors, or the bulk of his debts is to few creditors. The debtor would be able to use special provisions in the law to undergo expedited reorganization proceedings, or some would call prepackaged reorganization or fast-track reorganization. Another notable addition in the law is the licensing and regulation of trustees who will oversee the reorganization or liquidation proceedings. Under the law, a trustee must be licensed and must satisfy certain conditions to qualify. They must also attend a course and pass an exam organized by the Ministry of Justice. Also, another feature of the law is a special chapter which deals with cross-border insolvencies. This chapter addresses issues related to assets within Bahrain of an entity which is undergoing bankruptcy proceedings in a foreign country. This chapter is almost identical to the model law on cross-border insolvency produced by the United Nations Commission for International Trade Law on CITRL. Bahrain is the only country in the MENA region to include these provisions in its bankruptcy law. One important thing to mention is the new law eliminated the concept within the old law, which strips a debtor that undergoes bankruptcy proceedings of his civil and his political rights. This concept was probably one of the most important things which really stigmatized bankruptcy proceedings in the past. The old law stripped a debtor who undergoes liquidation under the old law of his economic right and his political rights even. He will not be able to stand up for election or even to elect in parliamentary or municipal elections, or even for BCCI election or professional associations. Also, for 2 years, he will not be able to engage in any commercial activities, commercial agencies activities, or export or import or securities, public auctions. So he will not have these rights for 2 years. It is probably worth mentioning that the Egyptian law of 2018, although it's a new law, still retained that concept. So what are the types of proceedings that a business entity that is facing financial difficulties can undergo? Well, these either reorganization or liquidation. If there is a chance for the entity to stand up on its feet again, then it would be reorganized. Otherwise, if there is really no chance, it would have to be liquidated. Having said that, the emphasis would always be to reorganize the business entity that is facing difficulties wherever it is possible. Wherever it's not possible, it would have to be liquidated. So when an application is made to the court for reorganization, the court probably will seek the advice of an interim trustee on whether there is a reasonable opportunity or chance for the business entity to be reorganized. Otherwise, the court will order liquidation of the business, again, upon advice really of an interim trustee usually. The same thing, the application is probably made for liquidation, but the court will probably decide that there is in fact a reasonable opportunity for the entity to be reorganized, and would order reorganization instead. Having said that, even if the court orders reorganization, later on during the proceedings, again, upon advice from the trustee, the court will decide to switch the proceedings from reorganization to liquidation. Vice versa, the court will probably initially approve an application for liquidation, but later when things become clearer, and again, sometimes during the proceedings, the value of the assets changes. So the court will have the power to order the proceedings to be switched into reorganization instead of liquidation. Now, what are the tests to be satisfied for the court to accept, to open reorganization or liquidation proceedings? Well, there are two tests. Any one of them would be sufficient if the applicant can satisfy it. The first test is often referred to as the cash flow test or the commercial insolvency test. It's really about cessation of payment by the debtor for 30 days. For 30 days, the debtor was not able to pay his debts as they fall due for over 30 days. The second test is referred to as the balance sheet insolvency. This means that the total value of the assets that are available to the debtor is less than the total value of his liabilities. This test is not really to be interpreted literally, and if there is more time during the Q&A sessions, we can elaborate on this test further. An important thing to consider as well is the cost of proceedings. How much does it cost to go through these proceedings? Well, there is initially a court fee to be paid by the applicant, and this is not much. But if the court approves to commence proceedings, the court will order the applicant to pay a deposit on account of the costs and expenses of the trustee. Later on, during the progress of the proceedings, the court will have the power to order the applicant to pay more money towards the cost of these proceedings. Otherwise, the trustee would recover his costs and expenses from the assets of the debtor, or from the revenue that the assets will generate later on during the proceedings. Of course, the debtor usually is the one who applies for commencements of insolvency proceedings, but also creditors would be able to apply for commencements of bankruptcy proceedings, but they have to be at least 3 creditors, and they should own a debt totaling BD 20,000 dinars at least. Some would wonder, why would a creditor wants to do that? Well, there are some instances where it would be really viable and in fact even advisable for creditors to consider lodging an application for the insolvency proceedings of their debtor. We can again elaborate on that further. The law very much emphasizes transparency in the proceedings. And as Fatima explained, there is a requirement for the Ministry of Justice to maintain a register for all cases related to insolvency. And in the register, you would be able to see almost everything that is related to the proceedings that are taking place in each and every case. But the court would have power to redact certain information if they are of a commercially sensitive nature. Another important feature as far as transparency is concerned, and that would enable really the creditors to be engaged, is the right that is provided in the law for the creditors to approach the trustee or the court if they choose for information about the debtor's business and his financial affairs and measures ordered during the proceedings. There is often a time lag between the time an application is submitted for the court to approve the commencement of bankruptcy proceedings and the time that the court finally decides on the application. So during this time, the court would have power to order conservatory measures where these are necessary. These are usually to preserve the assets, to prevent the dissipation of the assets. They also may include the appointment of an interim trustee to oversee the business of the debtor until a final decision is made. They may also include a temporary stay on certain legal actions that are pending or about to take place in the court to enable the debtor to continue his business before a final decision is made on whether to accept or deny the application for the commencement of bankruptcy proceedings. Thank you very much. I believe I have to hand over now to Shashank from KGB.
That's brilliant. Thank you very much indeed, Dr. Jamil. And my apologies for the technical issues that interrupted you the first time round. Okay, so on we go to Shashank, who's going to talk to us about trustees, mentioned briefly by both Dr. Jamil and Fatima. Over to you, Shashank.
Thanks a lot, Tom. As Dr. Jamil and Fatima rightly mentioned, the trustee plays a very central and a key role in the implementation and management of the proceedings, whether it's a liquidation proceeding or a reorganization proceeding. The primary duty that the law has given to the trustee is to maximize the value of the bankruptcy estate while he's protecting the interests of the creditors, so that the distribution and all the interests of the creditors are protected fairly and equitably. The trustee also exercises some wide powers and authority over the debtor, his business operations, as well as his assets. The trustee exercises the same power as the debtor himself when it comes to obtaining information or data from within the debtor's organization or from any third party who is interested with that information. The trustee is also authorized to attend the administrative meetings of the debtor, which means that if, say, a company is subject to the bankruptcy proceedings, so the trustee will have the authority to attend the meeting of the board of that company or any other high-powered meetings where any key decisions regarding the business are made. Throughout the work that the trustee will be doing, the trustee will obtain certain commercially sensitive information, which could include trade secrets, research and development related information, as well as customer information, which is commercially sensitive and maybe of some competitive advantage. The trustee is bound by a duty of confidentiality, which means that such information cannot be shared with any other third party, or the trustee cannot use such information for their own benefit. As Fatima rightly mentioned, the court supervises and controls the work of a trustee, even though the court as well as the law allows the trustee to function autonomously and make their own decisions in his own authority. There are certain cases in the law where specific approval from the court is required before any proposed measures are taken by the trustee. Some of the key professional qualities and characteristics which are required for a trustee to have include integrity, impartiality, and fairness. The trustee should also be independent of any economic or non-economic nature. He should be totally independent of any conflicts. That's why the law specifically provides that the trustee should not be an insider or a creditor of the debtor, or even he cannot even be the auditor of the debtor for a period of 2 years before the proceedings have been initiated. Given the complexity and the nature of his role, the trustee is also expected to have adequate qualifications and a good experience in the field of business where the debtor is operating. And also because of how the process of either liquidation or reorganization involves a lot of coordination between many different parties, as well as complex legal procedures have to be followed. The trustee is also expected to have very good management skills. Now, regardless of the nature of proceedings, whether it's a reorganization proceeding or a liquidation proceeding, there are some common responsibilities that the trustee has been given under the law. So as Dr. Jamil and Fatima mentioned, once the proceedings are initiated, once the proceedings are commenced by the court, a moratorium is imposed, which means that it's more of a stay of legal proceedings against the debtor as well as the bankruptcy estate. So the moment that moratorium is vacated, the moratorium is lifted, the trustee, if he seems appropriate, will be responsible for applying to the court for stay of all legal action and enforcement against the bankruptcy estate, if that's in the best interest of the creditors, as well as with the view to maximize the value of the bankruptcy estate. Now, for another key responsibility that the trustee will have is to collect the debtor's properties or rights, which may be in possession of any third party, and establish ownership on all of those property and rights. To allow the debtor to continue the business operations or to protect and preserve the value of assets, the trustee will also be responsible for obtaining unsecured creditor for the business, unsecured financing for the business of the debtor. Now, if it's a financing which is in the regular course of business, which is operational in nature, that the trustee can go ahead and apply for by himself in his own authority. However, for any financing which is outside the ordinary course of business of the debtor, for this a specific court approval is required to be taken by the trustee. In terms of documentation, the trustee is the moment the proceedings are commenced, the trustee is expected to prepare a report, a detailed report on the debtor's assets, the details of his business operations, and any other circumstances which affect the debtor's financial status. And this report must be submitted to the court. This could also be, the trustee could be appointed as an interim trustee before the proceedings are initiated, and such report will have to be prepared by the interim trustee as well, even before the commencement of the proceedings under this law. The trustee is also required to record data on creditors, which would include their names, their addresses, the amounts which are due to such creditors, the due dates for payments, as well as the nature of security against which the creditor has given finance to the debtor, along with the supporting documents and contracts if applicable. All of this record should also be with the trustee. As we discussed, the court supervises and monitors the job of a trustee. The trustee is also expected to present periodic reports to the court regarding all the measures which have been undertaken by the trustee and outcomes of such measures, and also update the court about any expected development in relation to those proceedings. In order to properly fulfill his duties and to handle his responsibilities, the trustee is also expected to retain certain experts, which could include legal experts, lawyers, accountants, financial advisors, who will assist him in performance of his duties and responsibilities as well as he can to the best of his potential. Now, moving on to the specific responsibilities upon the reorganization trustee, as Dr. Jamil mentioned, a key feature of this law is that during the course of a proceeding, if it's a reorganization proceeding, that can be converted to a liquidation proceeding. So it would be the responsibility of the reorganization trustee to monitor and review on an ongoing basis whether it's in the best interest of the debtor's assets as well as in the best interest of the creditors for converting the reorganization proceeding to a liquidation proceeding. Another key, or rather the most important responsibility of the trustee in a reorganization proceeding would be to prepare and finalize the reorganization plan proposal, which will be negotiated with the creditors and finally put to the court for the court's approval and implementation. During the course of these proceedings, once the proceedings have been initiated, the trustee is also expected to supervise the debtor's management of his business operations to ensure that the debtor is managing his business to the best of his abilities, to make sure there is no loss in the value of the bankruptcy estate. And also the trustee is expected to periodically review and assess the business performance, and where there are areas for optimization and improvement, the trustee is also expected to prepare a viable program to improve the performance of the debtor's business. Now, there may be cases where the debtor's authority to manage his business may be terminated by the court. This could be because of negligence, because of gross mismanagement. In such cases, the trustee, the reorganization trustee, automatically assumes the management authority over the debtor's business. Now, if once the stay and the moratorium is lifted, where the assets, the bankruptcy estate is subject to any judicial, arbitral, or administrative disputes, it would be the responsibility of the reorganization trustee to represent the estate in such proceedings. Moving on to the role of a liquidation trustee, similar to what I mentioned earlier, even in a liquidation proceeding, the trustee is expected to review on an ongoing and a regular basis whether it's in the best interest of the estate as well as in the interest of the creditors to convert the liquidation to a reorganization. As soon as the court approves the liquidation proceedings, the trustee is expected to take immediate possession and control over the bankruptcy estate without any delay, and also at the same time implement certain key measures to protect and preserve the value of the bankruptcy estate. Now, the trustee is also responsible for determining whether it would be appropriate for the value of the estate to maintain a part or entire business of the debtor. So if it's not even viable for the trustee to continue the business of the debtor, then the business should be seized. Whereas if the trustee is of the view that continuing the business of the debtor would lead to maximization of the estate, as well as it would protect the interests of the creditors, then he may choose to do so. Now, in case the liquidation proceedings have started and the trustee is of the view that the debtor is not capable or is not the right person to manage the business of the debtor during that period, the liquidation trustee can apply to the court for an approval to manage the business of the debtor for a fixed period of time until the proceedings are completed. Vis-a-vis the creditors, the liquidation trustee is also expected to audit all the claims which have been made by creditors or any parties which have interest in this case. He is expected to verify the accuracy and the genuineness of such claims. And where there are any doubts about the genuineness or the claims, the trustee is also expected to file objections against such claims before the court. The trustee is also expected to prepare the plan for the sale of a bankruptcy estate, for sale of individual assets, and he's also expected to undertake that sale for the realization of cash in order for the distribution to the creditors. And again, the court expects the trustee to prepare periodic reports which would contain the details of the assets which have been sold, what are the sums which have been received, and what are the expenses which have been incurred in the course of the sale of such assets. So we have discussed some of the key responsibilities of the trustee, but I think at this stage, it would also be relevant to touch upon briefly about the responsibility that the debtor who is subject to the bankruptcy proceeding, the responsibilities that the debtor has towards the trustee. The key responsibility is for the debtor to cooperate fully with the bankruptcy trustee, regardless of the nature of proceedings, in good faith, and in order for the bankruptcy trustee to carry his duties and responsibilities. This would also mean that where any data, any information is required from the debtor should provide such information without any delay to the trustee, and such information should be true to the best knowledge of the debtor. The debtor is also expected to consult the trustee on any decision or on any acts which are outside the ordinary course of business. So which means if these are business decisions concerning the sale of goods and services, which is the normal course of business of the debtor, and he continues to retain the management authority over his business, such matters may not be brought up to the trustee every now and then, whereas all other matters which are not within the ordinary course, which are not within the trade of the debtor, all of such matters must be brought to the attention of the trustee and discussed with the trustee before any measures or before any actions are taken. And also, as Fatima rightly mentioned, the debtor is also expected to prepare the draft reorganization plan and submit that plan to the trustee for his review and for further negotiation with the creditors, as well as to put it forward before the court. And throughout the process of preparation and finalization of the reorganization plan, the debtor is expected to assist the trustee in doing his job. In case of a liquidation proceeding, without any delay, the debtor is expected to cooperate with the liquidation trustee to allow the trustee to take immediate possession and control of the bankruptcy estate. So in conclusion, as we have discussed, the trustee does play a very key and an integral role as part of the proceedings under this law, which makes it very critical for the trustee to perform his duties with due care and diligence while being impartial, independent and fair to all the parties which are part of these proceedings and which have interest in these proceedings. Now, I would like to invite Matt to tell us more about what makes a good reorganization proceeding based on his experience in Australia.
Let me just interrupt you just for 1 second. Can I remind you that if you have questions, and we've had some great questions in already, but if you have questions that you'd like to put to the panel, please use the chat app to send those in. We have lots to talk about, and as Shashank has just said, we're now going to have a look at something that maybe we move from the theoretical to the practical. And we've got Matt, who's been at the sharp end of some reorganizations and liquidations in Australia, as well as here in Bahrain. So over to you, Matt.
Thanks, Tom, and thanks, Shashank. And of course, yes, I can see those chat questions coming through. So if anyone wants to ask a question, I'll try and answer those in respect to the piece that I'm doing now. So hello to you all from Melbourne, Australia. I've been asked to give you a guide as to what elements make for a good restructuring plan and a good restructuring trustee. So firstly, what does a good restructuring plan look like? What are the elements of the plan that would enable its success? And first and foremost, as Shashank said just before, the directors and management are involved in that restructuring plan. They would assist the trustee to develop something that is able to take the business forward. And typically that would involve an analysis, as Shashank said, of the cash flow and sales forecasts for the business. Are they reasonable and achievable, taking into account all the known factors? Clearly we're in a difficult environment now with the pandemic, so there shouldn't be any blue sky in terms of those projections. They need to be, as I said, reasonable and achievable. Other components of the successful plan, the business needs to have access to the required funding on reasonable terms, and the stakeholders, especially the creditors, as already stated, are kept informed throughout the process with written reports, responses to telephone calls on a timely basis, and updates to the company's website. Employee claims are typically paid as a priority, and I think Fatima covered off on that in her presentation. and related party claims may be deferred to a later period. Often, as you can imagine, the directors, the shareholders of the business are the ones that are also creditors in the bankruptcy situation. So it's often helpful that those parties defer their claims to a later period. Okay, moving on, what makes for a good restructuring trustee? The trustee would engage with all stakeholders in an honest and transparent manner. And in this, Australia is very similar to the new law which Bahrain has adopted. It's a statutory obligation here. So again, I support Mr. Shashank and Dr. Jamil's earlier comments. The trustee is realistic, as I said, in assessing the cash flow forecasts and the restructuring plan, and is able to give a clear explanation and reasoning to the creditors and the court on why the proposal and the plan results in a better return to creditors than a liquidation, which of course is a terminal scenario. The trustee should also seek to expedite the process so as to minimise possible damage to the business and resolve the creditor claims as soon as possible. By example, the equivalent process in Australia can be completed with a return of control to the directors within 8 weeks of commencement. A distinction here, as opposed to Bahrain, is that the courts aren't necessarily involved in the process. The courts can be, and they can give direction to the trustee. However, it's not mandatory. So by way of a few examples, the first one I will give is Engineering Structure Retention Proprietary Limited. This is a company that had a $100 million turnover business. However, during the period leading up to 2018, it had poor control over its project estimation costs, site supervision, and cash flow. Disputes with major customers and suppliers resulted, and that we had project walk-offs where contractors, suppliers would not provide the services that had been requested. And I know of one small masonry business, a sole director of this company. It was owed a loan over $800,000 Australian, which is roughly the equivalent of 200,000 dinar. Repayment arrangements are often outside normal trading terms. And of course, following meetings with the directors, I was appointed administrator or trustee in your terms on the 8th of November 2018. With the directors, we developed a restructuring plan. Ahead of my appointment, the company ceased operations with existing contracts and remaining employees assigned to a related company. 2 meetings of creditors were held, and at the second meeting on the 12th of December 2018, a majority of creditors, including the ATO, voted in favour of a restructuring proposal. The proposal included the directors contributing $200,000 to a creditor fund, deferring related party claims, as I indicated earlier, and giving the trustee the right to recover all property, including a debtor's ledger of over $1.5 million Australian dollars. The trustee executed a binding deed with the directors on 28 December 2018, and I spent the next 18 months pursuing the debtors through the courts to pay a small dividend to creditors. Unfortunately, it wasn't as big as we initially indicated, but the process for debt recovery, as you can imagine, in any part of the world is always difficult. And the creditors, whilst they did receive some funds, the business was able to continue, albeit in a new company. So that's an example of a construction business. The next one's Virgin Airlines. I note there's a question there. Typically, the legal exposure of corporate guarantors is the moratorium operates to their protection as well. So normally you wouldn't pursue a guarantor during that moratorium process. However, I'll allow one of the other speakers to answer that question in terms of what happens in Bahrain a bit later. So Virgin Airlines started in the year 2000 as what we call a low-cost carrier. Initially, it traded as Virgin Blue, and its focus was on the Sydney-Melbourne route, which some of you may be aware is the second busiest in the world. The business progressively expanded, both the route network, domestic and international operations, creation of a business class category, club lounges, and over 100 different aircraft, operating 6 different aircraft types. Of course, that adds additional layers of costs. A lot of these contracts that it had entered into, IT outsourcing, catering, baggage handling, were unprofitable, and there was underinvestment in the online booking platform. As you would all be aware, this year the COVID shutdown came, and over 75% of the 9,500 employees were stood down in late March, early April this year. And at that time, the cash burn rate for Virgin was about $50 million per week. So the management and the directors of Virgin were already working on a restructuring plan, but the effect of COVID was terminal, and the administrators, or trustees as you call it there, Deloitte's, were appointed on 21 April 2020. Immediately, they look to reduce the network capacity, and it's understood that that will drop from about 125 to 90 routes when the airline relaunches operation. All international flying has been cancelled, and the company will reduce in size to about 60 to 70 aircraft from the 100, 120 now, and flying only the Boeing 737. The airline lounges will be cancelled, most of those. They will take over the Velocity frequent flyer platform that operated under a separate ownership structure. However, with 6.8 billion Australian dollars in debt, including 2 billion of bondholder debt, which also takes in the Singapore Sovereign Wealth Fund, the formal restructuring is required. And whilst, as I said, the administrators don't have to immediately head off to court, there have already been various court applications to clarify the rights of various parties to information during this process. The administrators called for expressions of interest on a global basis, and 2 US private equity firms were shortlisted, being Cyrus and Bain Capital. Bain Capital is the party that emerged as the best offer, according to the administrators, and they're now renegotiating various contracts. There are about 160 contracts that needed to be renegotiated with major suppliers, license holders, aircraft leases, etc. The Bain Capital Group have also provided an initial $120 million working facility to enable the restructuring process to continue. Even with the administrators appointed, I understand that the cash burn rate is still about $25 million a week. So at this point, the creditors have not voted on the restructure plan formally. I understand that the report that the administrator is going to send out will come in early August, with a second creditors meeting on the 26th of August. And finally, one further case study, Tiger Lily. It's a swimwear brand here in Australia. It was started about 20 years ago. It was sold as a trade sale for $6 million in the year 2007, and then subsequently to a private equity fund for $60 million in 2017. Loaded up with too much debt, as you could imagine, it expanded to over 20 stores and 200 employees across Australia. There was diversification away from the core swimwear brand. And of course, with COVID striking here in Australia, Mentha were appointed as administrators, I believe in March this year, and they're working on a restructuring plan. As you can imagine, that's going to be the closure of the majority of the bricks and mortar stores, reduction in employee numbers, online clearance sales, and a renegotiation of supplier arrangements. Currently, the administrators have a expression of interest campaign looking for a new trade or private equity buyer. Again, until the second meeting of creditors, the administrators can apply to court for a deferral of that meeting date, and the creditors can then vote once a buyer is found. So thank you again for listening to me. If there's any further questions, happy to answer those. Over to you, Tom.
That's brilliant, Matt. Thank you very much indeed. And three really good case studies that I think a lot of people on today's webinar will find something in common with. I know that there are lots of questions, and I know that Matt, Dr. Jamil, Fatima and Shashank have been answering some of the questions as we go along. If you would like to ask a question, can I remind you that there is a chat function on Zoom. We have got still well over 100 people on the webinar. So please, if you have any questions, just send them in. I have got a couple with me to share with you, which I will do now. Let's start with the first one, Matt, which is aimed at you. A review of the Australian position suggests that there's not very much involvement from the courts.
Yeah, that's correct, Tom. The situation when this law was first designed, it follows more the English principles rather than the US Chapter 11 regime. And the courts are certainly there. The courts do have an overarching power, such as what Dr. Jamil indicated, but they there's no necessity to go to court. And if matters aren't in dispute, as I said, the whole process, the administration process, can be resolved fairly quickly.
Okay, super. Thank you very much, Matt. And then a question about moratorium. Now, I think both Fatima and Dr. Jamil talked about moratorium. So argue amongst yourselves who'd like to answer this one. But the moratorium begins once creditor and debtor files for bankruptcy, or is it once a trustee is appointed?
So it's once the proceedings are open, with the ability of the court to decide on the moratorium starting even earlier as an interim measure.
Yes, this can be part of the conservatory measures which the court can order. The moratorium does not have to be total and complete, as the moratorium that will kick in once the court approves the commencement of the bankruptcy proceedings. The court will probably be faced with an application to stay certain proceedings, whether an ongoing case or maybe even execution of a certain judgment, the seizure of certain assets for the purpose of selling them on account of a certain judgment debt. But yeah, I mean, this will be really part of the conservatory measures that the court may order. If you just allow me, there was a question asking about the third-party guarantors of the creditor.
Yes, that's
Would
right.
they or the moratorium apply to them? No, totally, absolutely does not apply to them. The moratorium does not really apply to the guarantors. If you have a case against the guarantor, you can proceed ahead unhindered.
Dr. Jamil, there was a question for you also about cross-border insolvency provisions, and it was to try and get a little bit more detail on that and how it can benefit Bahraini creditors.
Well, this is really about foreign proceedings. This is about a foreign entity that is going through foreign insolvency proceedings, and he happened to have certain assets here in Bahrain. It is really primarily about that. So it really protect these assets. Sometimes, of course, Bahraini creditors have rights against these assets or in these assets. So it would be really in their interest to prevent these assets from being dissipated and from being taken over by the foreign trustee, and generally really to enable the foreign trustee to manage the business that is related to these assets which are located in Bahrain and which are owned by the foreign business entity.
Okay, and a question here, which I think probably all four of you might want to give some input to. Does the entity filing for bankruptcy have a say in the choice of the trustee? So maybe, Fatma, we start with you, and then get Dr. Jamil and Shashank and Matt to add to your answer.
Sure. So the law allows for the creditors to have a say in the choice of trustee, but not the debtor.
And is that the case also then in Australia, Matt, or would it be slightly different in Australia?
Yeah, that's a good distinction, to be honest. Typically, the company finds itself in distress. As Dr. Jamil indicated, someone is trying to execute against the company. No surprises, in Australia, the Australian Taxation Office is the corporate cop. It's the one that's chasing people all the time. So typically they get a notice from the tax office that if you don't do something, they're going to wind up the company. So the directors will go and see their accountants or their lawyers, and those people will then suggest or recommend a trustee to act in respect of that entity. So there's a two-step process here. The directors can appoint the administrator or the trustee, but the creditors then get a right to replace that trustee if they're concerned about a lack of impartiality and independence, as Mr. Shashank said earlier in his presentation. So there's your difference.
Very good. Shashank, you did sort of talk about why trustees could be removed from a case, but I suppose this is the front end rather than the back end.
Sorry, could you repeat your question, Tom?
You talked about the reasons for a trustee being removed from a case, right?
Right.
But this is slightly different. This is actually the appointment of a trustee. So is there a panel that people choose from, or how does that actually work?
So there is a register with the Ministry of Justice. It's called the Experts Register, which contains the list of all trustees that are licensed within the kingdom. And I think, as Fatima rightly mentioned, the recommendation will be made by the creditors or the creditors committee to the court based on the qualification as well as the experience of that particular trustee regarding the business of the debtor. And only then the court will appoint. So in short, yes, the debtor does not have a say in the appointment of the trustee, which I believe is the legislative intent, because the primary reason for the appointment of the trustee is to protect the interests of the creditors. So I believe that's the legislative intent for allowing the creditors to choose the trustee rather than the debtor.
Would you like to add to that?
Yes, I think as Tom said, even in Bahrain, once a creditor is appointed, of course, after being selected by the creditors, or if there is no one selected, then the court will appoint him. The situation in Bahrain under Article 47, it enables the debtor or the creditors committee or the creditors that own more than 10% of the debts to apply to the court to replace the trustee in certain instances. And of course, one of them is if he is not competent or if he is impartial, then the debtor himself can go to the court if he wants and request the court to replace the appointed creditor. Now, there is also a situation where the debtor will have probably a strong say in appointing the debtor, and that is in the prepackaged reorganization. Usually, the debtor would approach his few creditors and agree on a reorganization plan, and also probably agree with them on the trustee who would be tasked with overseeing the reorganization. Now, as far as the question about the trustees, which trustee can be appointed, well, as Shashank said, trustees, they have to be licensed in Bahrain. So the appointment really would have to be made from those who are licensed. Any person who wants to be licensed as a trustee, he would have to apply, and he has to demonstrate that he satisfies the requirements, and he has to sit for a test and attend a course organized by the Ministry of Justice.
Excellent. Thank you very much, Dr. Jamil. A question, I think, for you, Fatima, regarding foreign creditors. How does the court communicate with them and inform them about the procedures? How long are they given to respond to court before court decides to proceed with bankruptcy or reorganization? Or is that something the court decides on a case-by-case basis?
Right.
We can hear you, Ms. Fatima.
Right. Is the question on the chat?
It's the question at 11:47 regarding foreign creditors.
Mm-hmm.
How do courts communicate with foreign creditors? How does courts inform foreign creditors about procedures? How long are foreign creditors given to respond to court before the court decides to proceed with either bankruptcy or reorganization? Or is there no set rule? Is that something that's done on a case-by-case basis?
Okay. So in terms of cross-border insolvency, it applies to assistance applications submitted by a foreign court or representative in connection with any foreign proceedings, and assistance applications submitted in a foreign country in connection with insolvency proceedings under the new law, and any foreign proceedings initiated against a debtor at the same time as proceedings initiated with respect to the same debtor under the new law. And applications as well that are submitted by a creditor or any foreign stakeholder for the initiation of or participation in insolvency proceedings. So there will have to be an application by the foreign creditor in order to be included in the proceedings.
Okay, excellent. Dr. Jamil, did you want to add anything to that answer?
Well, if you know, in the case of domestic proceedings, of course, the creditors would be notified of the application in the same manner, whether they are domestic or they are foreign. And the method of notification will be exactly the same as the notification under the Civil and the Procedural Act in the court. The summon will be made to them in the usual manner, just like any court case that is being filed.
Super, thank you very much. Fatima, and then a question again at 11:47 for SPCs, for individual establishments. Mm-hmm. Are personal assets listed by the trustee? Are they subject to court proceedings?
Mm-hmm. Right, and I think what is meant by that is whether or not the personal assets will be included in the estate under the disposal of the trustee. We've explained that there are assets that are exempt from being included in the bankruptcy estate, and those are social assistance by the state to the debtor, funds non-attachable by law, and this includes the place of residence, so the home, and the tools essentially required for the debtor's profession and continuity of business, as well as mandatory pension rights and spousal and dependent support.
Okay.
So is the family home exempt there? Sorry to interrupt, Tom. Is the family home sort of protected, Fatima? Is that what you're saying?
Yes. There's a protection under the civil law for family homes.
That's fantastic. I wish we had that here.
I was about to ask you, Matt. So you don't have that in Australia. So if you're an individual establishment, basically all of your assets are put before the court.
Yeah, I take it it's what do we have? What do we call here? We have proprietary limited companies. So over there, is it LLC? Is it the company form?
WLL.
Yeah, WLL. That's right, with limited liability. Sorry, thank you. That's correct. So when you say an individual, you mean like a sole trader? There's no corporate protection, Tom.
That's right. It's called proprietorship.
Yeah, sole proprietorship. Thanks, Dr. Jamil. Yeah, exactly. In those situations, yes, the family home is at risk if the property is in the name of the sole trader. That's correct. Yes. So most people form companies here, Tom, because you need the protection of the corporate entity to stop that. But the way around that, unfortunately, is we do have what's called an insolvent trading regime here. And what that means is that if the trustee can demonstrate that the directors continued to trade the company when it was not possible to pay its creditors, then they are personally at risk for insolvent trading under our laws here, yes.
We have a similar provision under our company law.
Yeah, it's fairly a high standard to establish though, Dr. Jamil, I assume?
It is, but basically if he is using the assets for his own personal benefit, then he would be liable, personally.
Yep, no, fair enough. That's the way it's all meant to work, yes.
Fatima, I'm going to put two different questions together. I hope that's okay, which is about time and cost. So what would be the acceptable duration between the total stop of the organization process to the application of bankruptcy? And I think this question is a bit like how long is a piece of string? How much does the process tend to cost?
Yes. Okay, so in terms of cost, I think Dr. Jamil gave a good overview of cost. If we can go through it quickly, the costs, there's a nominal court fee of 40 BD for registering the case, and then around 2% of the total debt amount to be distributed amongst the creditors as a court fee. But the court fee can be deferred or waived in part or in full by a decision of the minister, and then you have the costs, of course, of the trustees and any experts involved in the proceedings, whether reorganization or bankruptcy. And in general terms, we can say that there's a standard of reasonableness that the courts will apply in determining the fees or the costs of the trustee and experts. In terms of time, I think the first question was within how long shall the proceedings be commenced, and in that we say that the law doesn't really say within what specific time, but it does allow for guidance and says that if the debtor is unable to pay his debts within 30 days of the date of their maturity, or is expected not to be able to pay within that time, or when they become mature. So I think we can use this 30 days period in the law as a guidance, unless Dr. Jamil, you have any further guidance on this point?
No, I think, as you said, I mean, if he fails to pay for over 30 days, then, the test is satisfied.
Yeah.
Okay, Dr. Jamil, I'm not sure I'm completely understand the question, but it's a question at 11:48. If a trustee refuses bankruptcy application and the entity files...
I think the question is if the court refuses.
Presumably. Shouldn't there be a protection mechanism to protect shareholders and the company from creditors until the appeal issue is resolved? All creditors have been alerted the company has filed for bankruptcy and accordingly filed for claims the moment the trustee issues the verdict. And again, I take your point. I think it means the court, because the court presumably issues a verdict, not a trustee.
That's right. Well, there is always the possibility of applying for conservatory measure. And that would include, of course, a temporary moratorium pending a final decision on the application.
Okay.
That is available to the applicant from day one when he deposits his application for bankruptcy proceedings.
Okay, thank you very much. Shashank, a question for you. Who assigns the trustee? Is it the court, a debtor, or a creditor? Do parties have a say in choosing trustees?
So the court is the one who appoints the trustee, but recommendations are taken from the creditors or the creditors holding a certain percentage of the unsecured debts, as well as from the creditors committee. The debtor does not have a say in the appointment of the trustee.
Okay. Fatima, what is the legal exposure of corporate guarantors during bankruptcy or the moratorium period?
Mm-hmm. Yes, and I think Dr. Jamil already answered that. Is that correct, or shall we?
Yeah, that's right, yes.
Yeah, okay, beg your pardon. Are there special criteria to deal with those who have government contracts and support from Tamkeen or other government support programs?
Yes. What is protected is support from the state, and that is social assistance by the state to the debtor. So not all forms of support from the government is protected and not included in the estate. Only social assistance by the state to the debtor is protected.
Okay, super. Thank you very much. Shashank, a question for you. If an organization is still not operating and applies for bankruptcy, do you have to have a trustee?
Yes. Again, the court will appoint the trustee because you need to have a party to entrust all of the responsibilities which are provided for in the law for completion of the proceeding, whether it's a liquidation or reorganization. So even as Dr. Jamil mentioned, in case of a fast track reorganization, even a trustee is required in those cases.
Okay, thank you very much. Dr. Jamil, a question at 1213. If a businessman is a shareholder in 3 companies and he is the personal guarantor of loans to the 3 companies, if he wants himself as partner to apply for bankruptcy in all 3 companies, is that possible? Or should the company apply separately for bankruptcy? What if partners in one company refuse to apply, but the person himself is the personal guarantor?
Well, the debtor, as we already pointed, the debtor can apply for commencement of proceedings, and also creditors can apply. Now, the law is not really very clear on whether a guarantor can apply for commencement of bankruptcy proceedings. I would venture an opinion on that, and I would say if he really can demonstrate an interest in the commencement of the proceedings, then his case will be acceptable.
Thank you.
Because he will be eventually a creditor.
Another question on cross-border for you, Ms. Fatwa. If a debtor applies for restructuring or bankruptcy in Bahrain, does this apply to assets outside of Bahrain?
Yeah, we didn't include a lot on cross-border in this presentation. I don't know, Dr. Jamil, do you want to comment on that?
Can you say the question again, Tom?
Absolutely. So if a debtor applies for restructuring or bankruptcy here in Bahrain, does that process apply to assets outside of Bahrain?
Yes, it certainly applies to assets out of Bahrain, but you would have to have a country where the assets is located to acknowledge these bankruptcy proceedings. And in the case of Bahrain, we have this sort of provision. So if a foreign proceeding is ongoing in a different country, and if they come to Bahrain, they apply for recognition of those proceedings, of those foreign proceedings.
That's correct, Dr. Jamil. So both Australia and Singapore are signatories to the UNCITRAL UN agreement, as is Bahrain. That process should be fairly straightforward, surprisingly.
So the assets are located in Australia. The trustee,
I would help you out, Dr. Jamil, not a problem.
the trustee can safely go to Australia and file for an application for the recognition of the Bahraini trustees, of the Bahraini proceedings.
That's correct, yes.
Matt, a question that came in for you, and again, it's an Australian example. Are administrators personally liable for trading liabilities of a company in administration in Australia?
They most certainly are, Tom, and that's a big problem. The way the law was drafted, the administrator is personally liable. So if there was a workplace accident, if there were insufficient funds to pay the wages due to the employees, the administrator is liable for those amounts. And it's something that forces us to be very careful in terms of our decision-making as to which companies we allow to continue to trade. Is that the situation, Shashank, over in Bahrain as well?
In terms of like allowing the debtor to continue to trade or not?
No, in terms of the trustee being personally liable for the debts of the entity continuing to trade.
No, that's not the case here.
Yeah, so that's more like the US model.
Only be liable in case of gross negligence or display of incompetence. Only in those cases will the trustee be liable.
That's appropriate. Yeah, that's fair. I think that's the better way to go, to be honest. I think the Australian model is fairly onerous from that perspective, Tom.
Okay, thanks for that. Shashank, a question for you. And you talked about drawing up a reorganization plan, the trustees drawing up reorganization plans. And you are qualified, so Dr. Jamil's talked about the process that people have to go through in order to qualify as a trustee. But when a trustee is drawing up a reorganization plan, what do you see as the key guiding principles in that process?
So again, like the common theme that has been spoken about throughout our webinar, the key purpose is to achieve the best results for the creditors, because the primary objective of the trustee is to make sure that the interests of the creditors are protected. The other thing would be that, as I think Matt had highlighted earlier in his piece, that the reorganization plan that is drawn up should be implementable in a very reasonable manner, and it should also be based on some realistic assumptions and not projections which are based on very aggressive assumptions. Should be realistic and conservative assumptions. Also, all the parties which are part of the proceeding, they should be dealt with very fairly and with equity. And again, no part of the reorganization plan should be in violation of the terms and conditions provided for in the law. And as Fatima mentioned, all of the creditors should consent to implementation of this reorganization plan, which means that it should be consensual. It should not be that only a particular group of creditors is happy with the reorganization plan and the others are not. So it should be a consensual plan.
Okay, great. Thank you very much. Dr. Jamil, a question, and I'm going to put two questions together there if I can. So we were asked, what was the difference between bankruptcy and insolvency? And so if you have a company that's kicked out of its premises by court order, equipment is sold by another court order, the only assets are cars which are paid for or are being bought through loans. So there's no cash flow, no location, no company, no premises, and debts exceed 120,000 dinars. Are we looking there, first of all, at bankruptcy, or are we looking at insolvency? And then the second question, I think, is what would you suggest that someone should do in those circumstances?
Well, it's a very good question. Insolvency and bankruptcy, well, they both mean the same thing. Some legislation use the word bankruptcy, some use the word insolvency, but they basically amount to the same thing as far as English is concerned. Now, as far as Arabic is concerned, we have a word for insolvency, and under the civil code that is really used for basically bankruptcy of individuals.
Okay,
Our preference really in the law was to use the word insolvency throughout, because that would really apply to entities who will undergo liquidation and entities who are just facing some financial difficulties and want to go through reorganization. Our preference really was to use the word insolvency, but that did not happen because under our civil code, the word insolvency really is reserved to individuals.
Okay, thank you very much. So I think between us we've answered a couple of questions around foreign creditors. If foreign creditors have not been notified and the company was approved for bankruptcy, what can foreign creditors do to claim its entitlement? Presumably that goes back to the point that you were making, Matt, about UNCTRAL.
Yeah, no, I would have thought that the creditor can apply to the Bahraini court to be recognised as a creditor that's entitled to prove. Clearly there's a cost involved, so you would probably only be doing this if there was a significant debt owing by the WLL company in Bahrain. Is that right, Dr. Jamil? I assume that's how it would operate.
Well, the application for recognition would be really primarily for foreign entity that is undergoing insolvency proceedings. So they would apply for recognition of those foreign proceedings in Bahrain. But if they are foreign creditors to a Bahraini entity which is undergoing insolvency proceedings in Bahrain, then these guys will be notified as the domestic creditors will be notified.
Okay, thank you. Ms. Fatima, if a debtor applies for bankruptcy and is behind on their rent, would that stop or would that pause any form of vacation order for the company premises?
Right. So what the moratorium will do is stop all execution proceedings against the company. But in the case of an evacuation, of course, the courts will also have to balance between the protection of the debtor and the application of the moratorium and the rights of the lessor. So I think the courts will look at each case and decide suitableness of the evacuation or otherwise based on a case-by-case basis.
Excellent. Dr. Jamil, would you like to add anything to that?
No, thank you.
And I'm very aware of the time. We're at 12:40, so maybe we ask one or two more questions and then give Ms. Fatua a chance to wind up. But a question here, in a situation when the board directors give personal guarantees, are their assets seizable? Are their assets open to seizure?
The answer is yes.
And would that be the situation also in Australia, Matt?
Yeah, but typically the banks and other people that may have been provided with those guarantees won't commence action until there is an outcome in respect to the corporate entity. So if there is an administration regime and if there's a proposal that's accepted and the company's able to continue to trade, the financiers may not take action because there may be a go-forward strategy that they are agreeable to. But if it's terminal, if it's a liquidation as opposed to a restructuring, eventually they'll get the letter in the mail, but they may wait 3 to 6 months from the commencement of the company proceedings.
Excellent. So a final question for you, Dr. Jamil, and maybe Fatima, you would like to kick in as well. Why is a balance sheet test acceptable grounds for commencing insolvency proceedings? A debtor may have more liabilities than the value of their assets, but is paying debts on time, and there's always a chance the value of those assets will increase if the company continues in business. Why should that person undergo insolvency proceedings? Dr. Jamil, can I ask you to answer that one first?
This test actually is not to be applied literally. It is often the case that a business entity has very little by way of assets, but it has potential to make money in the future. So the way the court would approach this, the court would have to decide whether, based on a balance of probability, there is a reasonable chance, taking into consideration the business entity's prospective and contingent liabilities in the future, whether it would be able to survive, whether be able to continue to do its business.
Okay.
And this is often the case with business, with service entities. Let's take an example of a restaurant. Probably this restaurant has very little by way of assets, but it has a very good chef and has a good name. It has liabilities, and the liabilities are more than the value of the cooker and whatever, and a few chairs and tables that it has. It has potential to make business, although it is in debt now, but it can continue, and in the future it would be able to really have have assets more than its liabilities.
Excellent. Okay, and I have been begged. They said, please answer this one. So this is absolutely the final question. Again, a reminder that we will share all of the slides. We will try and put together a question answer sheet for the questions that we've been asked today. And if you have questions that we haven't answered, please send them in. But what about guarantee checks, Fatima, that we have given to banks and landlords? Will applying for bankruptcy protect us against criminal cases, or affects judgments from jail to fines?
Right, so the bankruptcy and reorganization proceedings under the new law have no effect on the criminal proceedings. So if there are criminal proceedings against the debtor, then that will continue. That will not be subject to the moratorium.
Thank you very much. Dr. Jamil, would you like to add to that answer?
No, I think, Fatima is perfectly correct. The moratorium really is related to the assets and the rights and obligations of the debtor and nothing else.
Okay, with that, ladies and gentlemen, thank you so much, really so much for your questions, and thanks to our panel for their fabulous answers. We're going to wrap up. We said we would try and do this in an hour and a half, so we've gone over by 15 minutes. But what I'd like to do is thank all of you for being a fantastic audience. I'd like to thank my panel again, and I'd like to hand over to Ms. Fatur, who will close our webinar for us today.
Thank you, Tom. On behalf of BCCI and my committee, which is the Finance, Insurance and Tax Committee, I'd like to thank our speakers, Dr. Jamil, Mr. Matthew from Australia, Shashank, Ms. Fatma, and Mr. Tom for moderating our event today. Great thanks to all of you for making time, and a great thanks for our audience for being so attentive and engaged, and for all the questions. As Tom said, we will hopefully have this recording posted or sent to you, and also a sheet for the question and answers, which are all valid and very interesting questions. I think the objective of today's session was to really highlight the key attributes of the new law. And I believe we have succeeded in that. Of course, it's a new area and we have lots of questions and not enough time to answer everything. But just to go briefly over what's been said, the main objective of our new law is really to emphasize reorganization over liquidation, to improve creditors' recovery and promote rehabilitation. And our law also offers tools to obtain this outcome as described earlier, whether it is appointment of trustees, a moratorium, allowing operations to continue through preserving value, business value, rather than liquidation, allowing or describing, allowing orderly process and flexibility to maximize value. And majority creditors can give approval or only needed to give approval. So really, I believe we have covered all the key attributes and of course the role of the trustee, which Shashank spoke about. Matthew, very much sincere thanks for giving us your viewpoint from Australia.
My pleasure.
Very informative indeed. And once again, thanks to everyone concerned and for the time, commitment, speakers, Tom, and our wonderful audience for being with us today. BCCI organizes and engages with the business community on an ongoing basis. You can check the website. There are numerous webinars, be it on each sector actually that we are involved in. We have 9 sector committees, and each one has various activities. So I encourage the business community to check the website and to select those webinars or seminars that suit or address their concerns. I wish everybody a good day, and I hope to see all of you once again in another interesting seminar. God bless you all. Have a good day.
Thank you.
Thank
Thank
you.
you.